Mr. Nave, Mr. Valet, are we ready?
Yes, we are.
All right. We're on the record. This is file 23-2307 FT, People of the State of Michigan versus Brandy Sue Jones. Would you state your name for the record, please?
Brandy Sue Jones.
Thank you. And Ms. Jones is appearing via video from the Montcalm County Jail. She is represented by Matt Nave, who's present in the courtroom. Also present in the courtroom is Chief Assistant Prosecutor Ryan Valet. Ms. Jones, we're here for purposes of arraignment on a felony complaint. It is alleged that on or about August 8th, 2023, in Eureka Township in Montcalm County, Michigan, that you did commit the offense of failure to stop at the scene of an accident when at fault, resulting in death. It's alleged that being the driver of a Volkswagen Jetta who caused an accident upon Wise Road near West County Line Road, property open to the travel by public, and knew or had reason to believe that you had been involved in an accident, did fail to immediately report the accident to the nearest or most convenient police agency or officer in order to comply with the requirements of state law when there was a reasonable and honest belief that remaining at the scene would result in further harm, and stop the vehicle at the scene of the accident and remain there until you had complied with the requirements of state law. And the accident resulted in the death of Jamison Lafferty. Ma'am, this complaint carries a habitual offender third offense notice. Therefore, the penalties of this offense are subject to enhancement, twice the maximum sentence on the primary offense. Therefore, this is a felony punishable by up to 30 years term of imprisonment and or a $20,000 fine. And a defendant may be convicted for each death arising out of the same transaction, and the court may order consecutive sentencing. Count 2 alleges that you did fail to stop at the scene of an accident resulting in serious impairment or death. It's alleged that you did, being the driver of a Volkswagen Jetta who knew or had reason to believe that you had been involved in an accident upon Wise Road near West County Line Road, property open to the travel by the public, did fail to immediately report the accident to the nearest or most convenient police agency or officer in order to comply with the requirements of law. When there was a reasonable and honest remaining at the scene would result in further harm, and stop the vehicle at the scene of the accident and remain there until you had complied with the requirements of state law. And the accident resulted in the serious impairment of a bodily function or death of Lucas Allen Lawrence. Ma'am, that is a felony punishable by a term of imprisonment of up to 5 years and or a $5,000 fine. Count 3 alleges that you did fail to stop at the scene of an accident resulting in serious impairment or death. It's alleged that being the driver of a Volkswagen Jetta who knew or had reason to believe that you had been involved in an accident upon Wise Road near West County Line Road, property open to the travel by the public, did fail to immediately report the accident to the nearest or most convenient police agency or officer in order to comply with the requirements of state law. When there was a reasonable and honest belief that remaining at the scene would result in further harm, and stop the vehicle at the scene of the accident and remain there until you had complied with state law. And the accident resulted in the serious impairment of a bodily function or death of Zeke Robert Rausch. Ma'am, that is a felony offense punishable by a term of imprisonment of up to 5 years and or a $5,000 fine. Ms. Jones, do you understand the charges and maximum penalties that the court has read? Ma'am, you
Habitual offender notice applies to that.
okay, the habitual offender applies to all the counts. Ms. Jones, the habitual offender notice applies to all counts, therefore all counts are subject to doubling or twice the maximum penalty. Count 1 would be a maximum period of up to 30 years term of imprisonment and or a $20,000 fine. Count 2 would carry a maximum penalty of up to 10 years term of imprisonment and or a $10,000 fine. And count 3 would carry a maximum penalty of up to 10 years term of imprisonment and or a $10,000 fine. Ma'am, do you understand the maximum penalties of the offenses that you've been charged with? Ms. Jones, you do have the following rights. You have the right to remain silent Anything that you say or write can be used against you in court. You have the right to a preliminary examination. You have the right to be represented by an attorney at all court proceedings. You have the right to have an attorney appointed at public expense if you cannot afford one. You have the right to have an attorney present during any questioning, and you have the right to be considered for pretrial release. Ms. Jones, do you understand the rights I've read to you?
Thank you.
Ms. Jones, the court will enter not guilty pleas on your behalf, and this matter will be set for a probable cause conference on Wednesday, August 23rd, 2023 at 10 a.m. and a preliminary examination on August 29th, 2023 at 12:30 p.m. Mr. Nave, do you have any comments regarding bond for Ms. Jones?
I do. So, as the court is likely aware, Ms. Jones has a parole hold. She's not going to be eligible for release. So while I definitely request a reasonable bond in this file, it's informed by that. And if that status does change, we can file the appropriate motion.
Thank you. Mr. Valet, do you have any comments for the people?
We'd ask for a bond no less than $500,000. I would point out in this case that Ms. Jones attempted to, not only she committed the offense, she attempted to hide the evidence of that offense afterwards. I would also point out that, as Mr. Navy stated, she's on parole. She met with her parole officer the next day. She was tested positive for methamphetamine. These are all concerning facts. She is a clear danger to the community, and we'd ask for an appropriate bond.
Thank you.
The car was at my house where it belongs. Where it was registered.
Ms. Jones, please don't talk right now.
This is retarded.
In setting bond, the court must take into account public safety, the defendant's criminal history or criminal record, the likelihood of appearance as well. Ms. Jones has a criminal history, as indicated by the parties today. She's currently on parole for an offense. It was a manufacture of methamphetamine, convictions out of the 8th Circuit that included parole conditions. That the probable cause that was taken on the warrant earlier today by the court, as well as what Valet had indicated, were violations of parole conditions. The defendant has criminal history spanning back to 2012 for various misdemeanor offenses. The gravity of this offenses are serious. Additionally, with the information provided during the probable cause, as it pertains to what Mr. Valet had indicated, that ultimately the court was advised during probable cause that the individual had stated she knew something had happened and had found out the next morning. That's of concern as it pertains to Ms. Jones not only availing herself to the court as she's on parole, but the court also has in the file an advice of rights that has a Eureka Street address, and the criminal history has a Belding Street address from which she's paroled to. The court is going to And the parole hold is not something that the court is going to consider at this time. If the parole board lifts that, that is not this court doesn't have any control over it. That is the decision of the parole board. They choose when they set a hold and what is done with that. So the court is going to set bond at $1 million in this case, as there's a loss of life, 2 serious injuries, as well as the indication that there was attempts not to avail oneself to the proper authorities. If bond is made and the parole hold is lifted, the following conditions will apply, Ms. Jones. You are to personally appear for all court hearings. You are not to leave the state of Michigan without permission of this court. You are not to commit any crimes while on release. You are not to use, consume, possess alcohol, marijuana, illegal, controlled, or mind-altering substances. You're not to be in the presence of anyone using, consuming, possessing those substances. You're not to enter into any bars, casinos, or other establishments that serve alcohol. You will be subject to drug and alcohol testing at the direction of the court, law enforcement, or pretrial services. That could be urine, breath, saliva, hair, or blood testing. You will be required to have a GPS tether through pretrial services before release and comply with all conditions and rules. You will be subject to random drug and alcohol testing no less than 2 times per week, randomly through the Office of Community Corrections Pretrial Services. You're not to possess, use, or purchase any firearms or other dangerous weapons. You are not to have any contact, direct or indirect, with any of the victims or their families. You're not to assault, harass, intimidate, beat, molest, wound, stalk, or threaten, or engage in any other behaviors that would place those individuals in reasonable fear of bodily injury. You're not to go to any place where they may work, live, or attend school. You will be on house arrest if bond is posted. The only exception for leaving would be in medical emergencies, drug and alcohol testing, or court hearings, or meeting with an attorney as it pertains to this case, or parole agent. You're not to operate any motor vehicles of any kind. You're not to have any contact with any person on probation or parole, and you're not to engage in any assaultive or antisocial behaviors. And that will be a $1 million cash or surety bond. Ms. Jones, do you understand the conditions that the court has read to you?
No, I don't. I'm done with this. I can't live in here.
Ms. Jones, what conditions don't you understand?
It doesn't matter. Just stop. Please stop.
Mr. Nave, do you have any comments?
No, I can meet with Ms. Jones to make sure she understands the court's requirements.
All right, thank you. Mr. Nave or Mr. Valet, anything further for this arraignment?
No, thank you.
Thank you. That will be all. Court's in recess.